morning. Thank you for having me. I used to, for 7 years, I litigated about 35 cases a day. I used to have nothing but insurance defense litigation cases, and I reached a point where I was going crazy, and I thought that being a trust and estates attorney would give me peace. Well, what I found out was that instead of fighting plaintiffs and personal injury plaintiffs, I'm now helping families try to work out their issues. So we still do litigation, but we don't at least have 35 cases. We have about 6 or 7 cases at a time, and it's a different type of litigation field. But the goal is to stay away from that and to do trusts, because what a trust does is a trust allows you to be able to control what you have and how the disposition of your estate goes to your family. So I have a small presentation, a guide to estate planning, what you need to know. What is the goal of estate planning? The goal is, and here's my definition, I want to control my property while I'm alive and able, take care of myself and my loved ones. I'm going to pick this up, okay, because it's a little... Take care of myself and my loved ones if I become disabled, and give what I have to whom I want, the way I want, and when I want, while saving every tax dollar, professional fee, and court cost possible. And that's what we all want to do. We work hard every single day to accumulate wealth, to live a good life, and what we want to be able to do when God calls us home is to be able to give to our family members or dispose of our assets the way we want. If I have a will when I die, things will work out fine. One thing in California that's a little different than other states, some states like Colorado may allow for the transfer of assets through a will. But in California, if you have a trust, that is the way you can transfer your assets without probate. A will guarantee probate, which means that you will be in the courts with me. I do a lot of probate cases. You're handing the problems to your spouse or to your loved ones. There's an unintentional disinheritance, because most of the time when people draft wills, they don't want to disinherit their family members, but they think what they're doing is they're giving their assets to their family members the way they want, and that doesn't happen, because you'll be in probate court with a will, especially if your assets are over $150,000 cumulatively. If a person was married, the surviving spouse only receives 1/3 of the estate, and the kids get the other portion. The probate fees are usually 4% of the first 100,000, 3% of the next 100,000, 2% of the next, and then 1% of the next 8 million. And so my fees to go to probate court in a very, very small estate typically start at around $7,000. A revocable living trust will cost you maybe $2,000 to $4,000, depending upon the size of your estate. It may be even less. If a person's unmarried with minor children, you're going to end up with a guardianship, because there's no way to provide for those children without the court-ordered guardianship. Your assets become public knowledge, and it takes 9 months minimum for a probate to close. Philip Seymour Hoffman, I know that you know him. He was a movie star that passed away recently. His assets, $34 million estate. He did not have a trust. And in the state of New York, like every other state, when you file a petition for probate with the courts, your assets are visible to every creditor, to every predator, to realtors, they're available for the public to see. When you have a trust, everything is taken care of outside of the view of the court system and outside of the view of other individuals. Robin Williams, who obviously we sadly passed away recently, had a trust and had a number of trusts. None of his assets are known by the general public. Probate court. Without proper estate planning, we must involve the probate court to transfer property. The probate court will appoint a person with authority to sell the real estate, which is, by the way, not only the administrator, but the administrator works with realtors. I work with a lot of probate realtors when we're in court. You need to notify creditors in the state and wait a minimum of 4 months before the court can transfer clear title. The court involvement will generally result in delay, expense, headache, and it may lead to a lost transaction. I have lost some real estate deals because of it. Property owned in other states also has to go through a probate. So if you have a property in Texas, we have to open a probate in California, and then we have to hire another lawyer in Texas to do the Texas probate. What if I transfer my property to my children by title? one of the things a lot of parents do is they say, okay, if even if I don't have a will or a trust, I'm going to go ahead and put my property into joint tenancy, or I'm going to give my kids the property. I'm going to hold property as community property or tenants in common and give my kids the property that way. Sometimes that works, and sometimes it doesn't. There's a risk of the loss of the property through divorce, bankruptcy, or lawsuit. Your assets, just because you have the house in joint tenancy, you're subject to creditors. There's no creditor protection whatsoever. You may not have the property go to the right recipient, especially when property is held in joint tenancy, because if a lot of times I see parents who will have a property held in joint tenant with their child, thinking that once they die, the child will receive 100% of the value of the real estate asset. But interestingly enough, that parent may have more children, and what they're expecting is that child to split the asset between the other kids. What I've experienced is that a lot of times, once one child has control of assets, a lot of times the asset doesn't get split. There's dissension, and there's difficulty between siblings, and that's when you end up with problems without a trust. There's a gift tax on transfers. You have a $14,000, you can give away $14,000 a year to your child tax-free. Your child receives that tax-free. Anything above that you have to pay tax on. And there's a lot, one of the biggest things, and people don't know about this, there's a loss in basis of step-up. So when you hold a property, for instance, in joint tenancy, and you have a husband and wife, the husband dies, let's say, wife will receive the step-up in basis because she's going to do an affidavit of death of joint tenant recorded at the county recorders. The property will become hers 100%, but then what ends up happening is then what mom does is mom goes into joint tenancy with John, and again, what happens is mom passes away. John gets only 50% step-up in basis. And what that means is John, the tax assessor, will go to the property, and they will reassess 50% of that property. So you don't end up getting the benefit of all that property tax. If you buy a house at $100,000 and the house is worth $1 million, you're paying property tax due to Prop 13 at $100,000. Not anymore if it's held in joint tenancy. The tax assessor is going to reassess 50% of that property. So those are some of the issues. Owning property jointly. You can have community property on your grant deed with right of survivorship. That does work between parents, but sometimes there is still court involvement. Domestic partners have the opportunity to hold property with right of survivorship due to the government turning down provisions of DOMA. Tenants in common. You can have property held as tenants in common. I deal with this a lot, where I have 3 or 4 different individuals holding properties. But the interesting thing is, as you all know, because you're realtors, is an individual who holds an undivided, maybe 1/4 share of property as tenants in common is able to dispose of that 1/4 share to their family members. So you end up with property that could be owned by a multitude of individuals. There's another way of holding title besides a trust, and it's by checking boxes, beneficiary designations, or they're called pay on death or transfer on death accounts. Some of my clients, they will go to the bank and they'll have a $50,000 bank account or a $150,000 bank account, and they'll say, when I die, I want my child to have my account. It's a pay on death designation or beneficiary designation. That works fine, but I have a situation right now that I'm dealing with in a conservatorship situation where mom had her daughter as a pay on death beneficiary of her account. It was about $300,000. There's 5 children. Mom's instructions to the one daughter was to, when she passes, and it was a separate property asset, not held as community property with her husband. She wanted the monies to go to her 5 children. Guess what the daughter did? She basically has 4 kids in college. She bought her son a new BMW. None of the monies were distributed to the other 4 children. So I'm in a situation right now where there's a lot of animosity between the family members. A revocable living trust helps to change this. Why can't I just give my property outright to my kids or loved ones? Because you are going to be exposing your kids to predators and fortune hunters. If your child does not know how to manage their monies, if they like spending money, they're going to have that money outright, and they're going to whiz through it in a couple of years. A trust allows you to hopefully protect that. You have immature heirs, same thing as a spendthrift heir. In-laws. Maybe you don't like your daughter-in-law or son-in-law and you want to protect the asset from, unfortunately, a non-blood family member. You have creditors and creditor claims. Loved ones with personal struggles needing to dip into the funds. Minors who are going to need a trust held until they're age 21. And then you have individuals with special needs who are receiving government assistance. They cannot have more than $2,000 in a bank account. Otherwise, the Social Security Department will try to recover the monies that they're giving. Estate planning basics. There are 4 types of estate plans. The first one is no planning at all. And I do help people with that. I usually am in probate court doing probates with people who don't make planning or don't plan. You have a title-based plan, again, community property, joint tenancy. You have a will-based plan, which is what we've talked about. You can do a last will and testament, and you can tell your executor who you want your assets to go to. But in the state of California, if you have assets over $150,000, you will be in probate court. The court will only allow $149,000 and under to be transferred through what's called a small estate affidavit. Otherwise, you're in probate court. And all of us here who are realtors, I used to be a realtor too. I sold real estate for 7 years, and I love what you guys do. I love real estate, everything about it. If you own a house or a condo or a small piece of property, you have to have that property in a trust. And it's one of the services you guys can offer. A living trust-based plan. A better way to transfer property to your children is considering to transfer assets in trust. It provides for asset protection against predators, creditors, divorce, and lawsuits. Your child can become a trustee of their trust at a specified age. The surviving spouse is still able to benefit, and it stays in the family bloodline. So, Fred and Wilma, if they don't like Bam Bam, they can give to Pebbles their house, the Bedrock house, and they can put that house in trust and still keep their daughter protected, because that house will be considered a separate property asset of the daughter. And if Pebbles divorces Bam Bam, Pebbles still gets that house. What is a living trust? It is a contract made between a trust maker and a trustee. An individual who drafts a revocable living trust, or a couple, married couple, you are the trustor, the trustees, the grantors, the grantees. You are in control of your estate. I like to look at a trust as a kind of a dresser and a big chest that has all these drawers with different guidelines, and they give blueprints and guidelines about how you want to get rid of your assets. So the living trust dresser, I'm sorry it's a little small, but these are some of the things that you can have inside of a trust. You'll be the initial trustee, the spouse and the individual, they create the blueprints and the guidelines. They say, upon my death, or the death of the second spouse, I want all of my guns to go to my son Kenny. I want my Cobra, and I've got a client who's doing this. I want my Cobra, which is worth $120,000, to go to Daryl. I want my business to go to another son. And these are the things that your clients get to decide. They get to create a blueprint of how they want to dispose of their assets. Inside of a trust, you can have things such as a disability panel, where if a person is incapacitated, you can choose between having 2 physicians determine the level of incapacity. You can go to court and determine incapacity, or you can have a disability panel where there's a number of individuals, including family members, who will help determine incapacity. One of the things I deal with a lot, which is really interesting, is not just death, but what I deal with is a lot of aging and elderly parents who struggle with incapacity. So both mom and dad are alive, but then I have a parent who actually has Alzheimer's or dementia. What do we do then? And a disability panel helps that. You have the option in the state of California and other states to have what's called a trust protector. A trust protector is an individual who is designated as a separate third party. It's kind of like the judicial system. You've got the checks and balances. And you've got this individual who, if you designate an individual to be your successor trustee upon the second passing of both parents, and you don't trust that individual, or you're worried that the successor trustee may not do what's right, you can designate a third party, kind of like the judiciary system, and they oversee that individual's actions and doings, check writing, what they're doing with the monies, and it's called a trust protector. That trust protector has the ability to go to court and to file pleadings with the court if that individual absconds with money or does things wrong. I because I do trust litigation, I see quite a bit of shenanigans, more than I thought I would ever see. And most of the time, everybody's good-hearted, and most of the time people get along. But we do see a lot. We do things happen, and so a trust protector allows for a level of protection. You're going to determine how your children can inherit wealth, whether it's outright or whether it's in a trust. Whether there's a step distribution trust, whether you want to give to your child at the age of 25, at the age of 30, at the age of 35, and then outright maybe when they're 40 or 50 years old. I have some parents who have children who have drug addiction problems. And so what we do is we draft provisions inside of our trust that states, if my child is able to be involved with, for instance, a program called Teen Challenge, and my child is sober for 3 years, begin distribution of his estate. If my child is not able to achieve soberness, then what we're going to do is we're going to give my child X amount of dollars per month for the rest of their lives so that at least they can live, but they will not receive their funds outright. These are some of the things you get to choose. There's things like administrative trustees, disability trustees, there's tax planning provisions, there's powers inside of a trust, and one of the interesting things too is there's something called a no contest clause. If you have kids that don't get along, or you're worried that what's going to happen is there's going to be bickering and fighting, and I see it a lot when there's larger estates, the no contest clause is a provision that we place in a trust. And it says, if you, child, bring an action in court for the purposes of harassment or for frivolous reasons, the court has the right to determine that you've predeceased your parent and you received nothing. And so what it does is it creates honesty, but what it does is it keeps everybody from thinking about, gosh, I think I'm going to hold back from harassing my siblings or trying to create problems. How can you choose who will make healthcare decisions and manage your finances if you are incapacitated? There's two concerns regarding control, incapacity, and death. Without advanced planning, if you're incapacitated, you may face a living probate, which could require court intervention. I do a lot of conservatorships and guardianships. When a person's incapacitated, sometimes even if you have a trust, if they struggle with dementia and it's not the good dementia, we will still get a conservatorship. I have a client right now who she has a very, very large estate. She has a very complex trust. Everything's provided for. Her kids are provided for. But she can't quit feeding the feral cats. She has 20 feral cats in her backyard and feral birds. And she only wears white. And she lives in a 6,000 square foot home by herself. And what's happening is the city, the police department, is now citing her and telling her that if you don't stop feeding the cats, we're going to have to actually take you to jail or do something. And this is a woman in her late 80s, and that's because of dementia. So we ended up with a conservatorship, even if we had a trust. Sometimes it happens. At death, your estate may require probate. We've already gone into that. Reasons for making an estate plan. Elaine, your husband's next wife. In the months since your death, she's brought home cooked meals to your husband 6 times. Each time she visits, she digs through all your old things. She can't wait to redecorate your home, especially that hideous wallpaper you chose, and thinks that there's no good reason that money is set aside for your children and should be spent on more important things such as jewelry, sports cars, and European spa vacations. Do you want Elaine to get your child's inheritance? This actually does happen a lot, and we call them, I know an attorney who calls them the pot roast ladies, where the wife dies and the husband is within 6 months got a girlfriend and she's bringing pot roasts over, and the monies are going somewhere else. So a trust helps with that. Another reason to make your estate plan, your daughter Victoria, who at age of 45 is on her 3rd husband, has a charge account at every clothing store in town, takes riding lessons, yoga classes, and has a personal trainer and wears shoes that cost $400. And her idea of taking care of the children is a full-time babysitter. Are you sure you want to leave your life's work to her? No strings attached. Another reason to make your estate plan, your granddaughter Amanda. She works as a waitress, and this is all stuff I've experienced. I want to tell you, this is not far-fetched. She works as a waitress. She goes to a different club every night, wishes to give everything she has to animal rights groups. Are you sure you want to leave all of your stuff outright to her? Reason to make an estate plan, your son-in-law Fred. He bosses your daughter and ignores your grandchildren. He hasn't had a job since 1991. He sells t-shirts at rock concerts. And you suspect he's fond of chemical substances, and he thinks it's great he has rich in-laws. Is he going to get half of what you leave to your daughter? And that's where we do those lifetime trusts. The last thing is for special needs, your son Andy. And this is really important. I have the ability to draft inside of my trusts a special need trust provision. So, Andy faces the world with sweetness and courage despite his special challenges. He needs continual practical assistance with daily tasks. He's easily upset by changes in his routine, and he flourishes with loving and care and attention. What will happen to him when you're gone? There's two ways to do a special needs trust. You can have court supervision, and you can have a third-party trust. And what you really want to do is provide for your special needs child before you die. And so what you do is you put a provision, a special needs provision inside of your trust that when you pass allows that child to have the trustee set up a special needs trust outside of the eye view of the court. A trust is not enough. You need to have what are called other ancillary documents. So when you do a revocable living trust, we're going to do a pour-over will, but the way I draft things, or the way I do my estate planning, is we want to think about the whole person. We want to think about the family. We don't want to just draft the trust. We want to think about what you need while you're alive. Revocable living trusts are good for when you're dead or for when you're you have incapacity. But while you're alive, what do you need? You need an advanced health care directive that says, I do not want to be placed on a PICC line. I want choice not to prolong life. Do not resuscitate. Some of you may be not old enough to remember the Florida woman who was on a PICC line for 9 years or 10 years, and there was a huge lawsuit in the Florida courts because why? Because she did not have an advanced health care directive that said pull the plug. Other things that you might want is a HIPAA release, a HIPAA authorization. You want a power of attorney for assets. So when you know, mom and dad, they probably have names on joint accounts, no problem. But if dad's incapacitated and mom ends up with maybe a hip replacement surgery, and again, I'm giving you circumstances that happen all the time, the daughter or the son or somebody who's named as the agent on the power of attorney is able to take that power of attorney and go to the bank and do your banking, to write bills, to pull money out, to do things that you can't do. Because why? Because everybody's tied up, and it happens all the time. So a power of attorney for assets is really important, and it's for when you're alive. These are the things you need when you're alive. Your pour-over will accompanies your trust. It's not really used, but it catches any assets you forget to place in your trust. And then you have other things you can do, like a personal property assignments, appointments of guardians for minor children if you have minor children, where my clients have young children, and appointments of conservators for self. Why would you want to coordinate your insurance, pension, IRAs with your estate plan? Because you want to make sure that everything coincides. You want to make sure your stocks are in your trust, your house is in your trust, that your Roth IRA may not be in your trust, annuities may not be in the trust. It depends, and again, you want to look at the whole picture. An unfunded trust guarantees involvement, court involvement. I have situations where we draft a trust, an attorney drafts a trust, and then he says to the client, by the way, it's your job to put your house in the trust. And the client doesn't realize that they have to draft a new grant deed, they have to do a preliminary change of ownership report, a PCOR, and then they have to record that with the county recorder. So what happens is they die and the house is outside of the trust. The house wasn't placed in the trust. You're right back in probate court. But it's a little bit of a different petition, but you're still in probate court. Not funding your trust follows your wishes from being carried out. And to fund or not to fund. Real property you'll always put in the trust. Your personal property we'll put in the trust. Bank accounts, it depends. Brokerage accounts we'll put in the trust. Business interests we will. Cars, recreational vehicles. Sometimes we do not put cars in the trust because if you drive down the street and kill somebody and your insurance policy is not high enough and the PI attorney wants to pop the policy, we don't want your trust as a beneficiary of your vehicle. Annuities, usually not. Life insurance, it depends upon your estate planning wishes. IRA and retirement accounts, typically not. You have beneficiary designations. How to avoid estate planning mistakes. A trust-centered estate plan. It's customized, it's comprehensive, it's fully funded, and in conclusion, not understanding that the biggest enemy is not the IRS, but we have the enemy, and the enemy is usually us. we are the ones usually that don't plan for our future. And the reason we end up in a situation where we're panicked is because we haven't thought about it in the beginning. Or when we're young enough, and I have clients that are 65 years old who come to me and say, it's time to do my trust, and I tell them usually, my goodness, you're lucky. Because I just recently had a client, he and his wife are in their 50s, he's worth about $10 million. They avoided doing a trust, because why? Because they have a blended family, they have 7 children. And they did not want to think about how to dispose of their assets because it was too painful emotionally to figure out how to give that money to their kids. Well, the wife had hepatitis C and she's always beaten it. This time she didn't beat it. She passed away and I had to probate some of his assets. It's a $10 million estate. He got lucky because a lot of it transferred, but some of it didn't. I'm done. Thank you very, very much for your time.